Punishment generally involves inflicting some kind of pain or loss on any person who has broken the law. It comes in different forms. Some countries impose the jail time, while others have the death sentence. Others simply require the offender to pay fines, while others beat up the offender in full view of the public. However, the key question for our lesson today is, what is the reason for punishing offenders in South African law? At the end of the lesson, we should find out what the state aims at achieving when it punishes offenders. In South African law, the reasons for punishing offenders are called theories of punishment. According to our law, one of the reasons given for punishment is simply because the offender deserves to be punished for breaking the law. Such a reason for punishment is known as the theory of retribution. Retribution therefore requires that there must be a proportional relationship between the punishment imposed by the state and the harm caused. In other words, the crime must fit the punishment. For example, when a judge imposes either a life sentence or the death sentence for the crime of murder, we can argue that the punishment given fits the crime committed. Another theory justifying why offenders should be punished is known as the deterrence theory. This theory is broken down into individual and general deterrence. In terms of this theory, the aim of the punishment is not because the punishment fits the crime, as in the case of retribution, but as a means of deterring the individual or society from committing crimes. Individual deterrence aims at teaching the offender a lesson through punishment, which in turn discourages him or her from committing further crimes. General deterrence, on the other hand, involves punishments which discourage the general society from committing crimes. The aim of this theory of punishment is that the punishment serves as a message to the general society on consequences of committing such crimes. Another theory for punishing offenders is known as the preventive theory. Do not confuse the preventive theory with the deterrence theory. For the preventive theory, the prevention of crime is the main purpose, whereas, with the deterrent theory, the aim of the punishment is to deter either the individual or the society as whole from committing crimes. Another theory is known as the reformation or reformative theory. This theory acknowledges that the problem may be the offender after all. Therefore, punishing the offender with the aim of preventing him or her or deterring them would have very little impact unless the offender's behavior is reformed. That is why, in terms of this theory of punishment, the focus is to reform the offender as a person, so that he or she may become a normal law-abiding member of the community once again. Our courts do not reject any specific theory, neither do they endorse a single theory as being the only correct one. However, our courts favor a combination of all these theories. This combination theory was used in the case of State versus Zinn in 1969. In this case, the court held that when imposing a punishment, a court must look at the impact of the punishment on the society, the criminal and the crime. In looking at the impact of the punishment on the criminal, the court could consider the reformative, the preventive, or the retributive theories. In looking at impact of the punishment on the society, the court could employ the deterrence theory. Lastly, in looking at the impact of the punishment on crime itself, the court could employ the preventive theory. Next time someone is punished for breaking the law, remember these theories. Thank you for watching my Advocatus. Please remember to subscribe to our channel for more content.